because we heard that argument several times about 30,000. We said 6,000 each we will contribute and
99.3% of the notes were exchanged.
or attorney will may offer. He stood up.
My learned friend can offer more.
Why should you deny it to the people with 30,000? What was your 1 lakh? 1,61,000. Why should he be denied? And that procedure that he followed was found to be a bad procedure, intended to favor people. Here, you don't know what's the material. Which is why I'm imploring your lordships to see the material, to see what they did and how they did it, step by step. The third and extreme step is demonetization, which affects everybody in the country. There can be no citizen who was not affected by demonetization. That extreme step, your lordships have to apply more rigorous standards.
Be done now. It is over now. First point we appreciate. Of course, 26.2, you want to say it won't come under 26.2.
Yes.
That is your legal argument. Yes. We will consider that.
Yes.
All the other points are all relating to past events, which is over now.
Right, but the law will.
That's why if you remember at the threshold, we said whether the writ petition survive.
Lordships have said, and I'll justify that submission. You will state the law. Please state the law. What is 26.2? What is the limit of its power? And what are the matters that should be taken into account? If your lordships hold that this decision, this process was flawed, material was not considered, that itself is good enough so that they will not embark upon such a misadventure in future. Lordship, I'll cite case law for that. The lordships have held that you can declare the law, even if no immediate relief can be granted to all the petitioners. But in the case of Mr. Diwan, if your lordships accept our argument, your lordships will consider giving relief to him. And the other gentleman who had 30,000 rupees, relief to him. He should be given relief. Why should he be denied relief? 99.
We were discussing about 30,000 because we heard that argument several times about 30,000. We said 6,000 each we will contribute and
99.3% of the notes were exchanged.
or attorney will may offer. He stood up.
My learned friend can offer more.
Why should you deny it to the people with 30,000? What was your 1 lakh? 1,61,000. Why should he be denied?
Then you will
99.3 has come back.
No, only thing what we were actually looking at was maybe your argument to say that 26.2 not followed the procedure that was required to be followed. On that we'll have to state whether that has been followed or not. Now, supposing that procedure was followed, I mean, at least that was my thing. Supposing we accept that procedure was followed and it was done for the same reason and the object was not achieved. So object wise, what we feel is that may not be very relevant. But whether they followed 26.2, as you rightly say, to come to a conclusion, and if it is wrong, to lay down for the future to say that it had to be followed.
But I'll be satisfied with that.
But for saying that these were the objectives and that has not been achieved may not be much relevance is what.
Well, it may not be relevant. Why I'm putting forward these objectives is
to say the urgency
that notification said.
To say the urgency, this was not the reason.
These are the objectives. Then what did you consider?
Correct. So what you say is 26.2 still for consideration. Yes, that's
firstly, whether 26.2 is limited, as I'm arguing, or is unlimited power. And assuming whatever the power in 26.2 was the process power, the decision-making process.
Correct. So that maybe to concentrate more on that would be better instead of saying the.
Well, I'm just one
failed.
page.
Instead of saying it failed.
I'm just
done. Failed, the procedure should have been followed is what it.
I've just completed, Miller. It's only one more page.
All right.
But even if the procedure had been followed, this impact or adverse effect could have also happened.
Not necessarily, Miller. If the decision-making process had been what it ought to be, And if they had taken into account all this data and material, they may not have, I'm saying, may not have withdrawn the 500 rupee note.
So what you're saying, the expert advice which they would have received would have made them change.
Like
mind.
Dr. Patel and Dr. Deshmukh said, this is not, why has there been no demonetization in any country that I know of in the last? Only with this hyperinflation they've demonetized. There's never been a demonetization.
See, the effect or the impact of a governmental action
Yes.
cannot have any real bearing on its validity.
No, no. Applying the test of proportionality, your lordship can say this was an unreasonable action. Your lordship may not be able to undo the effect of that action, but your lordships can say on applying the test of proportionality, this was an unreasonable action. In fact, my Lord Justice Ramasubramanian's judgment says exactly that. I'm strongly relying upon that judgment. Cryptocurrency, same government, same RBI. The court held, applying the test of proportionality, we don't accept this. Therefore, my Lord, I will be satisfied if your lordships agree with me, if your lordships are pleased to agree with me, that 26(2) is a limited power. If you want to demonetize all the series, you must have separate legislation. Number two, assuming under 26(2) you have the power, the decision-making process must be well documented, followed strictly in letter and spirit. You can't have such a opaque, hurried, rushed, reversed process. This is a reverse process. This is standing on its head. Those are the two main submissions, proposition 1 and 2. I'm satisfied, but other petitioners obviously will ask for relief. If your lordships accept that, then your lordships will have to consider here then whether they deserve relief even after 6 years. They've been waiting for 6 years to get some relief. They may get relief. Let me complete it, Malad. It'll take only 5 minutes.
Both these cases are pertaining to delegated legislation.
Yes,
Both these cases are pertaining to delegated legislation.
where the essential,
No, here it's not a
26(2).
26(2), it's not a quasi-legislative power. Quasi-legislative,
It is executive power conferred upon both RBI and central government. RBI to recommend, central government to notify. So Parliament can do it itself as it did in 46 and 78. Instead of Parliament doing it, it is now conferred a power upon the RBI and the central government. Leave out the first argument. Let's take only the second submission of it. Is that power on the RBI and the central government unguided, uncanonized? That is the
according to you, the discretion which is vested with the central government and with the RBI to make recommendation is totally unguided, uncanalized, and
Where is
therefore
the
it
guidance?
can be exercised in an arbitrary manner.
Where is the guidance?
that is different from saying these are all where essential legislative powers are given to an administrative authority. And it was held to be uncanalized or abdication of legislative power in these judgments. But now we are looking at a substantive legislation under section 26. Therefore, these judgments may not be apt.
Look, I'm relying upon the last sentence in paragraph 20. The power of regulation granted to the administrator under section 5(2)(b) suffers from excessive delegation of legislative power. Substitute the word regulation. We are of opinion that the power of notifying the currency notes which should be demonetized, that is the power conferred by Parliament upon the RBI / central government. That must have some guideline.
No, but
Here
it is in a substantive legislation under section 26.
Yes.
These are judgments where essential legislative power has been delegated and therefore they suffer the vice of excessive delegation in these two judgments.
Well, in
That is different.
that is the earlier sections,
Is without guidance.
What my lady is saying is applicable to the earlier sections where they upheld the power. They say there's enough guidance. 1 to 8 steps. What is the procedure he followed? And that procedure that he followed was found to be a bad procedure, intended to favor people. Here, you don't know what's the material. Which is why I'm imploring your lordships to see the material, to see what they did and how they did it, step by step. Well, the next judgment is 2018. Maybe this is what Justice Gawai. 2018, 18 SCC 83. This is also, my lord, another good case where they go into the procedure followed and later say a conclusion. The procedure is flawed. Kindly come to paragraph 30. Paragraph 30 at page 98. Just glance at, my lord, paragraph 22, I'm not reading it. The file of the ministry reveals. The file of the ministry reveals. And they set out all that from paragraph 22 to paragraph 27, where the defense minister expressed agreement with the recommendation of the Chief of Army Staff and approved the appointment of Lieutenant General so-and-so as a DGMS. So all this is set out, and now kindly come to paragraph 30. We are also one with Mr. Venugopal about the scope of judicial review. Not all that. Then, last line. However, scope of judicial review certainly extends to examining the decision-making process and to see as to whether appropriate process legally permissible has been undertaken while taking the decision. While undertaking this examination, the court can deliberate and ensure that all relevant factors are taken into consideration and correspondingly no irrelevant considerations have crept in the decision-making process. These are, among others, the accepted norms of judicial review. After all, discretionary powers conferred on the administration cannot be unguided. No doubt in such matters, the discretion exercised by the authorities is to be generally accepted. This does not, however, mean that there is no control over discretion of the administration. All powers have legal limits. There is distinction between decision-making process and the merit of the decision, whereas in the former, the court applies the standard of judicial review. In the latter, it enters into the merits of the matters. Then Lord Hailsham is quoted. Then kindly come to the conclusion at page 35, paragraph 35. This is what I humbly request your lordships to do. After examining the procedure and what their steps, we are thus of opinion that the process undertaken by the respondents in taking a decision to appoint Air Marshal so-and-so does not stand judicial scrutiny. We are constrained to set aside the plan. So they step one, the file is called, they look into it, culminate with the approval by the Raksha Mantri of the COAS's recommendation. After examining the procedure followed, they say this is bad. The last judgment, the last 2020, I'm only adding a judgment which adds some value. 2020, volume 10, Supreme Court cases 274. This is, my lord, Justice Ramasubramanian is the author of the judgment, dealing with cryptocurrency. Now, there are a number of paragraphs. I'm not going to burden your lordship with all the paragraphs. I just show the headline. Paragraph 163, mode of exercise of power. This paragraph is very important, Mullah. That takes us to the next question, whether the power is exercised properly in a manner prescribed by law. The argument,
Paragraph?
paragraph 163 at page 366. Left-hand page, Mullah. Mode of exercise of power. Para 163. That takes us to the next question, whether the power is exercised properly in a manner prescribed by law. The argument is that assuming that RBI has a requisite power to do what it has done, the necessary sine qua non is a satisfaction under Section 35A of the Banking Regulation Act as well as 45JA, empower the RBI to issue directions if it is satisfied. Satisfaction can only be arrived at by gathering facts, sifting relevant material from those which are irrelevant, and forming an opinion about the cause and connection between relevant material and the decision proposed to be taken. Please apply that standard to our case. Well, the other paragraphs I'm not reading.
But you must appreciate the plot of this case in the sense.
Yes.
It is written as if it is like a movie plot.
And it ends with the climax.
Yes, starting with the storyline and plot and ends with the climax.
My brother is saying that is there a Bahubali part 2?
Well, kindly come to paragraph
Unfolding the plot.
207.
But there was a villain actually. He has shifted sides now.
Oh, yes. 207. This is important, Miller. Test of proportionality is applied. But nevertheless, the measure taken by the RBI should pass the test of proportionality, since the impugned circular has almost wiped out the virtual currency exchanges out of the industrial map of the country, thereby infringing Article 19(1)(g). On the question of proportionality, the learned counsel to the petitioners relied upon the four-pronged test summed up in the opinion of the majority in modern tenting. The four tests are that the measure is designated for a proper purpose, the measures are rationally connected to the fulfillment of the purpose, that there are no alternative, less invasive measures, and that there is a proper relation between the importance of achieving the aim and the importance of limiting the right. The court in the said case held that a mere ritualistic incantation of money laundering or black money does not satisfy the first test, and that alternative methods should have been explored. Then kindly go to paragraph 215. There are a number of other paragraphs, but I'm not troubling since the 215. This is important again. One is the paragraph which I read applies the test of proportionality. This paragraph applies alternative methods. Thus, the ultimate recommendation made by the European Union Parliament in the paragraph extracted above is not to go for a total ban of the interaction between cryptocurrency business and the formal financial sector as a whole. Obviously, RBI did not consider the availability of alternatives before issuing the impugned circular. But by an interim direction issued on 21/8, this court directed RBI to give a detailed point-wise reply to the representation of the petitioner. Pursuant to the said order, RBI gave a detailed reply in 4 lines. In reply, RBI has dealt with every one of the contentions to petitioners. The relevant portion reads as follows. That is all set out, and then kindly come to paragraph 223. RBI's response was found to be unsatisfactory. 223. As we have pointed out earlier, the concern of RBI is, and it ought to be, about the entities regulated by it. Till date, RBI has not come out with a stand that any of the entities regulated by it, namely the nationalized banks, scheduled commercial banks, cooperative banks, NBFCs, has suffered any loss or adverse effect directly or indirectly on account of the interface that the VC exchanges had with any of them. As held by this court in the state of Maharashtra, there must have been at least some empirical data about the degree of harm suffered by the regulated entities. It is not the case of RBI that any of the regulated entities have suffered on account of the provision of banking services to the online platforms running VC exchanges. Then in para 224, it is no doubt true that RBI has very wide powers, not only in view of the statutory scheme of the three enactments, but also in view of the special place and role that it has in the economy of the country. These powers can be exercised both in the form of preventive as well as curative measures, but the availability of power is different from the manner and extent to which it can be exercised. While we have recognized earlier, elsewhere in this order, the power of RBI to take a preemptive action, we are testing in this part of the order the proportionality of such measure, for the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entity, but there is none. When the consistent stand of RBI is that they have not banned VCs, and if the government of India is unable to take a call, despite several committees coming up with several proposals, including 2 draft bills, both of which advocated exactly opposite positions, it is not possible for us to hold so the impugned measure is proportionate. I had empirical text. In the light of the discussions, petitioners are entitled to succeed. Impugned circular dated 6/4 is liable to be set aside on the ground of proportionality. Accordingly, it is set aside. Well, the final judgment is Swami, 2019, 1 SCC, page 1. This is the final judgment in this part, Miller. We don't have it. But in the meanwhile, can I read, Miller, my last judgment, 1982, 2 SCC 150, for the proposition that if you are relying upon Article 19(6) to defend yourself, the burden is upon the state. This is 1982. You got that? Volume 2 SCC. Right? 2019 is not here. Whichever. (1982), madam. 1982. 1982 SCC. 150. Only one paragraph, paragraph 19.
That they have to justify public interest.
They have, the burden is on them. Assuming paragraph 19 at page 163. assuming that the impugn notification making it obligatory to grant rebate for binding material when sugarcane is brought bound in bundles to the extent prescribed in the impugn notification does impose a restriction on the freedom to carry on trade. The next question is whether the restriction is reasonable and imposed in the interest of the public. Once it is assumed that the impugn notification imposes a restriction on the freedom, the burden is on those who support us to show that the restriction imposed by the impugn law is reasonable and is imposed in the interest of the public. So that is, the last judgment has put us on 2019, Volume 1, SCC, page 1. This is the lead judgment, Ballard, Justice Sikri. Paragraph 492. Nobody would keep black money in the blank bank account. Page 475, paragraph 492. Nobody would keep black money in the bank account. We accept the possibility of opening an account in an assumed name and keeping black money therein. My lords have the book.
Yes. Yes, yes.
However, the persons doing such an act, if at all, would be very few. More importantly, those having bank accounts of modest balance and routine transactions can be safely ruled out. Therefore, the provision in the present form does not meet the test of proportionality. Therefore, for checking this possible malice, there cannot be a mandatory provision for linking of every bank account. They were linking Aadhaar with every bank account. They said that is bad. Then I'll kindly come to the 495. The rules are disproportionate for the following reasons. One, a mere ritualistic incantation of money laundering, black money, does not satisfy the first test. No explanations have been given as to how mandatory linking of every bank account will eradicate the problems of money laundering and black money. There are alternative methods of KYC, which the banks are already undertaking. The state has not discharged its burden as to why linking is imperative. We may point out that RBI's own master direction allows using alternatives to Aadhaar to open bank accounts. 496, there may be a legitimate state aim for such a move as it aims at prevention of money laundering. However, there has not been a serious thinking while making such a provision applicable for every bank account. Maintaining bank account in today's world has almost become a necessity. All that is set out in the last 4 lines of that para. There should have been a proper study about the methods adopted by persons who indulge in money laundering, kinds of bank accounts which such persons maintain, and target those bank accounts for the purpose of Aadhaar. Does not be done. We thus hold amendment to Rule 9 or the 7th Amendment rules to be unconstitutional. And then 503, we are of the opinion that although such a circular lacks backing of law, it fails to meet the requirement of proportionality as well. It does not meet necessity stage and balancing stage tests to check the primary menace which is in the mind of the respondent authorities. There can be other appropriate laws and less intrusive alternatives for the misuse of such SIM cards by a handful of persons The entire population cannot be subjected to intrusion into their private lives. It also impinges upon the voluntary nature of the Aadhaar scheme. We find it to be disproportionate and unreasonable state compulsion. It is to be borne in mind that every individual resident subscribing to a SIM card does not enjoy the subsidy benefit of services. We have therefore no hesitation in declaring circular dated is unconstitutional. Lord, I have to conclude by saying, did they examine any alternative methods to deal with fake currency, to deal with black money? There's no evidence, nothing has been stated in the affidavits. Well, in a demonetization is an extreme step. And I'm concluding with this. There are three ways in which you can approach the problems associated with currency. The first is to stop issuing that currency, non-issue or discontinuance. That is the mildest step. Whatever has been issued is issued. I will no longer issue, or I will discontinue issuing 500 and 1,000 rupee notes. That is permissible under Section 24(2). Lordships are 24(2). That is the mildest step. I find there is too much fake currency, too much black money stored. I'm no longer issuing 500 and 1,000. All of you do with smaller currency notes. That is 24(2). The second is what the RBI did in 2005 and in 2014, namely replace the currency already issued by giving a window for exchange so that the old notes are phased out and the new notes take over. The new note has better security features, better design, less copyable, and the old notes will be phased out. And those notes which are not returned will be immobilized and become a scrap of paper. That is the second step they can do. The third and extreme step is demonetization, which affects everybody in the country. There can be no citizen who was not affected by demonetization. That extreme step, your lordships have to apply more rigorous standards. Did you have the material? Did you consider relevant material? Did you eschew irrelevant material? Did you follow a transparent process? Did you spend enough time and apply mind to the consequences? On that color, I submit this demonetization hopelessly fails. If there is one major economic decision taken in the last 10, 20 years, which affected practically every citizen, which was demonetization. That must be held to a much higher standard. And applying that standard, I would urge your lordships to declare that such a power is not available under 26(2). And if it is available under 26(2), then 26(2) itself would be unconstitutional. The process followed was deeply flawed. They did not apply the tests of proportionality. And therefore, your lordships may mold the relief